Good morning and welcome to the Tennessee Court of Appeals. Want to take just a moment and make sure that we're all on the same page before we get started. First of all, I want to thank the attorneys for agreeing to participate via Zoom. It seems like this is the way we've been doing things for a while. In fact, we've been doing this for nearly a year and a half now, and we appreciate you participating with us in this method. If we experience any technical glitches, and I certainly don't expect us to do so, but if we do, then everybody just hang on. We'll take care of it. We'll make sure that nobody's prejudiced by any problems that we may have. Before we get started, I want to introduce our panel for today. We have Judge Arnold Goldman from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. I also want to remind the attorneys that we will be following the same procedure as if we were in court today. The same rules apply. Each side will get 15 minutes to make its oral argument. If you're the appellant and you've reserved any rebuttal time with the clerk previously, you will receive that rebuttal time. If more than one party is arguing for a side, we'll need to know as you begin your argument how you're splitting that time as well. Ms. Angie, anything before we get started?
No, Your Honor.
All right, you may call the case.
Thomas A. Smythe versus 4th Avenue Church of Christ.
All right, we will hear from the appellant.
Good morning, and may it please the court. My name is Jeremy Goolsby, and I represent the plaintiff and appellant Thomas A. Smythe in this matter. The issue before this court center around the validity of an amendment to a land purchase and sale agreement entered into between Mr. Smythe and defendant appellee 4th Avenue Church of Christ, or the church. On April 19th, 2017, the party signed a contract for the purchase of the property. The agreement contained, among other things, a 60-day due diligence period, followed by a 30-day period to close. The church was aware from the outset of their negotiations and contractual relationship with Mr. Smythe that he was purchasing the property with the intention to develop it. During the due diligence period, Mr. Smythe learned that the property had an existing farm road easement as its main point of ingress and egress that was not suitable for the intended development. In order to develop the property, a new, wider easement would have to be obtained from the adjoining property owner. Throughout the original diligence period, the church and its expressly authorized agent, Douglas Buttrey, worked on obtaining the new easement access from the adjoining property owner. Additionally, the adjoining property owner held a right of first refusal to purchase the property, so a signed waiver of that right of first refusal would also need to be obtained before the sale could be completed. Mr. Buttrey assured Mr. Smythe that he was working on obtaining these documents, but by the middle of June, before the expiration of the original diligence period, the church was not able to obtain these documents, and the parties agreed to extend the due diligence period and subsequently the obligation by Mr. Smythe to close on the property to September 1st, 2017. At this point,
is it your position that it was the church's obligation to obtain the waiver and the easement?
No, it was the obligation of either of the parties. There was no express obligation that the church had to obtain these documents. And both the church and Mr. Smythe were reaching out to counsel for the adjoining property owner, who was the adjoining property owner died, so they were dealing with his estate. So the estate owned the adjoining piece of property, and both of the parties throughout the diligence period and as extended were reaching out to the adjoining property owner to try and get these two documents.
So thank you.
And yes, and so as the extended diligence period was approaching, the parties were still unsuccessful in getting these two documents. So on Thursday, August 25th, Mr. Smythe sent an email to the church through its authorized agent proposing another addendum to the agreement. The proposed terms of the amendment are clearly stated in the email and are as follows. The requirement for Mr. Smythe to close on the property is extended until the 2 documents can be obtained from the estate. Within 15 days of the receipt of those documents, Mr. Smythe would deposit an additional $140,000 in earnest money, which was fully non-refundable. And 30 days after the deposit of the additional earnest money, Mr. Smythe would begin to pay the church's interest on its outstanding mortgage until the closing of the property could be fully completed. On August 31st, the church, again through its authorized agent, stated that the church had approved the amendment language, quote, as submitted, and the church had decided to agree to Mr. Smythe's new terms. Now, the only terms that Mr. Smythe ever offered to the church were the terms contained in the August 25th email. Now, the following day, there was a mix-up with the document that was intended to formally memorialize this agreement. But notwithstanding that mix-up, over the following months, the parties both proceeded as if the August 25th amendment was in effect. That is, both the church and Mr. Smythe continued in their efforts to obtain the easement agreement and the waiver of right of first refusal. In fact, in October of 2016, the church was successful in obtaining the signed waiver of the right of first refusal. Further, and importantly, in connection with a capital contribution campaign for the church expressly admitted to its congregants that it was still under contract. Now, in November of 2017, the only way that the church could still be under contract is if the August amendment was still in place. However, on May 8th of 2018, the church advised Mr. Smythe that he had until the end of May to close, despite the fact that one of the contingencies in the amendment that triggered Mr. Smythe's obligation to close on the property had not been met. Now, these actions, this constituted a breach of the agreement, and Mr. Smythe was forced to file the underlying litigation. After some discovery was taken, the church filed a summary judgment motion, which was ultimately granted by the court. And in the trial court's opinion, they ruled that the amendment was not enforceable because the 2 emails didn't constitute an offer and acceptance. The parties failed to form a complete agreement on all essential terms, and there was no meeting of the minds or mutual assent between the parties. Now, not only was this holding in error, but the trial court's order also improperly resolved factual disputes in favor of the moving party, who was the church, drew inferences in favor of the moving party, and blatantly ignored certain material facts, which created a genuine dispute, all of which was improper at the summary judgment stage. So first, let's talk about the offer and acceptance piece. So an offer is a signification by one person to another of his willingness to enter into a contract with him on the terms specified in the offer. The August 25th email from Mr. Smythe clearly signifies his willingness to amend the agreement pursuant to certain essential terms that are specifically and clearly enumerated in that email. This email, simply put, is Mr. Smythe's unequivocal offer of these specific terms to the church, and it manifested his intent to be bound by them if the church accepted them. As such, pursuant to Tennessee law, the August 25 email does constitute a valid offer. Second is the acceptance. An acceptance of an offer is a manifestation of assent to the terms thereof made by the offeree in a manner invited or required by the offer. Acceptance has to be exactly and precisely in accord with the terms. The August 31 email from the church meets all of these requirements to constitute a valid acceptance under Tennessee law. It states, "Hello, Tom. All is well, and the church shepherds agreed last night to your amendment language as submitted. There were some last-minute questions, but those were resolved last night. We are still on track, and we appreciate your patience." As I mentioned before, the only amendment terms that Mr. Smythe offered the church were those contained in his August 25th email. The communication accepting that offer places no conditions on the acceptance or varies the terms of the offer in any way. So on
Mr.
August
Goolsby,
30th, yes,
Mr. Goolsby, let me interrupt you for just a minute. Did the communication that Mr. Smythe sent on August 25th reference any extension or proposed extension of the due diligence period?
It did not. And so
And that was set to expire on September 1. Is that correct?
That is correct. And the way that the amendment works and what the trial court erred in holding that the extension to the due diligence period was an essential term, but it was not. So before the contract was amended in August, Mr. Smythe's obligation to close on the property was triggered by the expiration of the due diligence period. After the agreement was amended in August, Mr. Smythe's obligation to close on the property was triggered by two conditions precedent, namely obtaining the new access agreement from the estate and obtaining the signed waiver of the right of first refusal. So the due diligence period did not have to be extended in order for Mr. Smythe's obligation to close on the property to be extended. And that's why the extension of the due diligence period is not an essential term to the amendment, and the trial court erred in holding that. So that deals with
Mr. Gillespie, is it your position then that after your purported August 25th email and purported offer that there was no deadline in effect? There was no deadline to the due diligence or to any actions that were to be taken from that point forward?
There was no hard date deadline, no. But the deadline for Mr. Smythe to close was triggered by the two conditions precedent either being met or not being met. That is, some affirmative, and it could be a situation where one of the conditions precedent was not met. All that would take was some writing from the estate saying, we're not going to sign the waiver of right of first refusal, or we're not going to grant you a new easement, at which point the condition precedent would be an impossibility. And from that point forward, Mr. Smythe would be forced to either close on the property or take his earnest money back and walk away from the deal.
And both of those conditions that you refer to, those were to be actions of a third party, not to be actions of either of the parties to this original agreement. Is that correct?
That's correct. Just obtaining the actions that the parties to the agreement had to do would be obtaining those documents, but they would still require some third party to, yes, sign the document. And it's no different than an appraisal contingency or an inspection contingency where you're requiring a third party to certify that a property is passes inspection, or to give somebody funding for the property. So I will reserve the rest of my time for rebuttal.
All right, thank you. We will hear from the appellee. I see that we have two attorneys here. Are you splitting time, or how are you working?
Your Honor, if it pleases the court, I'm Alan Hall, and this is my co-counsel, Julie Hamner, who is on brief, but in the spirit of like we were doing this in person, Ms. Hamner would be at counsel table with me, and I wanted her to appear in front of the court as well, to the extent possible.
That's fine. So you'll be making the full argument?
I will be making the full argument, Your Honor.
All right, you may proceed.
Thank you, Your Honor. May it please the court, Alan Hall of the Williamson County Bar. The court has got the issues, and I won't belabor them. I mean, it is very, very simple. This is a basic contracts, first year law school offer acceptance, and as the court has just asked Mr. Goolsby that he could not satisfactorily answer, in my opinion, there is an open-ended condition that could possibly never occur. It's not like an appraisal condition. It is not like or anything else. If the estate never chose to issue this easement, then we would still be waiting at the end of the day, and this land would be tied up. I think the trial court's May 28th order is really the best guide for examining this case. The undisputed facts are April 5, 2017, there was a contract entered into. And in that contract, it contained paragraph 5. Mr. Goolsbee continues to say the church agreed in this May 31st email, except that it wasn't the church. It was Douglas Buttrey. And he'll talk about agency and he'll talk about implied agency, but nowhere does he address the fact that the actual contract signed by the parties contains paragraph 5 that requires a principal to principal interaction. So from its clear face of the undisputed agreements that are in place, the April 5, 2017 agreement, there's paragraph 5 that requires principal to principal interaction. The August 25th and the August 25th email was a principal interaction, but Douglas Buttrey's reply email wasn't a principal interaction. Addendum 1 was signed on April 18th, 2017 by the church, its president and secretary, who also signed the initial contract. The church is an incorporated entity. It only acts through its board of directors, which in this case, the church calls them elders. The elders met, agreed, they authorized the president and the secretary of the corporation to sign the April 5th agreement. They authorized the church to sign Addendum 1 on April 18th. They authorized this church to sign Addendum 2 on June 18th, which Smythe signed on June 19th. The words of the emails aren't disputed. It's the effect that are disputed. The words of the emails, particularly the August 25 email from Smythe and the 831 response, do not constitute an offer and acceptance. And the court has a very well-reasoned opinion that goes through the whole litany of cases of offer and acceptance. And we point all those out in our briefing as well. And the court even said, even if the 825 email was an offer, conditional as it is, and it constitutes an offer, there was no acceptance because there was no meeting of the minds. The case is really that simple. Let's talk about the certain facts that Mr. Goolsbee says are contained in the July 25th offer. He stated, he being the attorney for the estate that was supposed to give this easement, he stated there would be no problem giving us written confirmation that the estate will waive any implied rights of first refusal and the church is free to sell their 20 acres at will. The estate will give a buyer that 20-acre parcel the right to purchase this unequivocal, non-conditional offer. A third party will give my client, or his client, the sophisticated investor, real estate developer, the right to purchase shared access directly from the estate. He goes on to state unequivocally that subject only to the receipt of those clarifications will I go hard. And then he says it could be based on Sandra Morris deciding, Sandra Morris was the executor of the estate, deciding between the options, including an outright sale and or a normalized sale contingent to zoning approvals. So this is the unequivocal offer that the appellant says is clearly capable of being accepted. Even if it was unequivocal, even if it was capable of being accepted, it wasn't what was accepted. We know what was accepted because Judge Woodruff's order states that. It's undisputed that the elders approved what Mr. Goolsbee refers to as a mix-up. The elders approved Julia Wood, Mr. Smythe's attorney, the appellant's attorney, sending a offer or an addendum 3 actually, and the elders met and approved that at its board of directors meeting. This is the reference to what Douglas Buttry makes when he says the elders met last night and approved your offer. And it is undisputed in the record that the elders met and did that. The affidavit of Tracy Herbert, the affidavit of Gary Schrader, the minutes from the board meeting, and Scott Hubbard's own emails suggest this. It's just not credible that a sophisticated businessman like Mr. Smythe, who has lawyers dealing with him, and oh, by the way, for the next year, for the next 8 months, however long it was, from July 25th till he said basically, get off the pot and let's go on. From that time on, it was, they were negotiating what the email exchanges referred to as the third addendum. If this offer, this email had been offered and accepted, then why wouldn't we be dealing with the fourth addendum? It just strains credibility to believe that. There was no meeting of the minds. In fact, Scott Hubbard, as pointed out by Judge Woodruff in his order, says so on September 5th to Julia Wood. So in order to find out where we stand, we must go back to the last meeting of the minds between our clients, which is found in addendum 2 of the contract. It's just clear. And then I do want to just tangentially address, which we addressed in a footnote, this red herring of the church's so-called admission. Even a secretary typing something in a bulletin and somebody reading that bulletin from the church pew does not an admission make for the purposes of this sort of thing. It is incredible to believe that that's all the appellate can come up with. I am happy to answer any questions the court may have, and I feel like a failure because I still got time left, but it's just this simple.
Mr. Hall,
Yes,
Go
ma'am.
ahead.
what does the record reflect regarding that, the last thing you mentioned there, the November announcement in the bulletin, I believe is the way you referred to it. What does the record reflect regarding the nature of that statement?
It just reflects that there was a bulletin and that there was a bulletin printed and this announcement was made from the pulpit. But even if that was an admission, you can't admit to something that's a nullity. So I guess it would be no harm, no foul if it was an admission because there is no contract.
Thank you.
You're welcome.
I see no further questions, and don't ever feel like a failure when you don't use all your time. Oftentimes it's much appreciated by the appellate panel if you said all you need to say, and we don't need to hear it time and time again. So thank you.
Thank you, Your Honor. Thank you.
We will hear from the appellant in rebuttal now.
Thank you, Your Honor. Just briefly, I think one thing that it's clear is the court's order, the trial court's order takes for granted a lot and resolves in the moving party's favor a lot of facts that are in dispute. It takes a lot of liberty.
What would those facts be?
So, for example, opposing counsel mentions this conversation and what the church shepherds voted on. Nowhere in the record is there any evidence of any conversation from anybody at the church or any of its representatives to the shepherds about what the terms of the amendment that they were voting on, other than Mr. Smythe's August 25th email, which constitutes the offer. So, and there's sworn testimony.
Are you saying that the the elders did not, or some representative of the elders did not file some type affidavit?
They didn't. Well, they did file affidavits, but, and they do say, here's what we voted on, and it's reflected in the minutes. But if you look at the minutes themselves, the minutes state what they voted on was based on a communication from Douglas Butchery that he received from Mr. Smythe. Now, Mr. Smythe's sworn testimony is the only communication offering terms to the amendment was the August 25th email. There was no conversation between Mr. Smythe between August 25th and August 31 where he offered some new or different terms for the shepherds to vote on. The only terms that he offered were those contained in the August 25th email. And
I'm having a little difficulty here, Mr. Goolsby, because I don't know that it's, at least from my perspective, it's as important what Mr. Smythe said to Mr. Butchery as what it is as important as what the elders actually approved. Isn't that really what we're looking at, is what was presented to the elders and what they approved?
so if we look at the meeting of the mind standard, we don't look at the undisclosed or secret intentions of the party. We only look at what their outward manifestations are and what is on the four
Don't we
corners.
know what that is because we have a record of what they voted on and what they approved?
Not at the time. I mean, the document where they say that what they voted on, it was based on a communication from Mr. Smythe to Mr. Butchery. The record shows that the only communication from Mr. Smythe to Mr. Butchery was offering those terms that he puts in his August 25th email. And if you look at the objective, like applying the objective standard, if you look at the four corners of the offer and acceptance, Mr. Smythe offers an amendment to the agreement that contains X number of enumerated essential terms. And in the direct email communication below, the church unequivocally states they accepted those terms as submitted. There's nothing in there about we voted on different terms than what is proposed in your offer. We decided to change up the terms and we have a counter proposal for you. It is very clear that the August 31 acceptance was an acceptance of Mr. Smythe's terms as he offered them in the August 25th email. There's no indication in there that they changed up those terms, and the record is clear that the only terms that Mr. Smythe proposed were the terms in the August 25th email.
All right, thank you, counsel. We appreciate your arguments. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We again appreciate your participation in this oral argument via Zoom. Ms. Angie, if you would recess court to the call of the next case, please.
This honorable court is in recess until 1 p.m.
Thank you.
Thank you.
Thank you.
Thank you, Your
Thank you,
Honor.
Jeremy.